Please rise. District Court for Passaic County is now in session. The Honorable Judge Adrian Hister presiding.
Thank you for sitting down. We are convened in State of Iowa versus James Anthony Tingle, case number FECR 012701. Today is the date and time set for hearing on the defendant's request to enter a plea of guilty. Present in the courtroom representing the State of Iowa is County Attorney Ben Smith. Representing the defendant is Peter Goldsmith. And Mr. Goldsmith is the person seated to your left, the defendant James Anthony Tingle.
Yes, Your Honor.
And Mr. Tingle, the court is informed at this time that you wish to change your plea to count one of the trial information to a plea of guilty. Is that correct?
Yes, ma'am.
Is what you are about to do being done freely and without any threats against you?
Yes, Your Honor.
How old are you?
24, sorry.
And what is the extent of your education?
I have my GED.
Do you have any problems reading, writing, or understanding English?
No, ma'am.
Are you presently under the care of a physician, psychiatrist, or psychologist?
No, ma'am.
Are you at this time under the influence of any alcoholic beverage or medication?
No, ma'am.
In the last 6 months, have you been in the hospital for the treatment of any physical or mental condition?
No, ma'am.
I'm required by law to personally advise you of your rights and determine if you are pleading guilty because you are in fact guilty, and determine if there is a factual basis for your guilty plea. Do you understand that?
Yes, ma'am.
If at any time you do not understand something, please let myself or Mr. Goldsmith know, and I will stop the proceedings and give you an opportunity to speak to him outside my presence. Do you understand that?
Yes, ma'am.
And do you agree to let me know if you need that time?
Yes, I will.
Also, at any time, if you change your mind and decide you don't want to plead guilty this morning, let me or your attorney know. I'll stop the proceedings, and nothing you say up to that point will be used against you. Do you understand that?
Yes, ma'am.
And do you agree to tell me if you change your mind?
Yes, I will.
Are you presently under any probation or parole?
No, ma'am, I'm not.
Do you have any charges pending against you at this time in
Yes.
any
Yes.
court anywhere?
Yes, I do.
In what county is that?
Ivy County.
What you need to understand is that while you may have a plea agreement with the state of Iowa, in this case, it may or may not affect any other cases that you have pending or are serving a sentence on. Do you understand that?
Yes, ma'am.
So in essence, if you are sentenced in another county in another case and then later sentenced in this case, those two cases could run consecutively or back to back. Do you understand that?
Yes, ma'am.
And knowing that you still wish to plead guilty?
Yes, ma'am.
Mr. Goldsmith?
Could I also point out that there are potential charges coming out of Plea County, and Mr. Tingle is aware of those also.
All right. And again, whether or not you have a plea agreement, which I'll get to in a minute, could affect the end sentence that you serve. Do you understand that?
Yes, ma'am.
And knowing that you still wish to plead guilty?
Yes, ma'am.
Have you received a copy of the trial information in this case?
Yes.
And have you had an opportunity to review that with your lawyer?
Yes, I have.
And have you discussed any possible defenses you may have with your lawyer?
Yes, I believe so.
All right. And Mr. Goldsmith, other than a general denial, do you know of anything which could affect the outcome of this case?
No, Your Honor.
And Mr. Tingle, are you a U.S. citizen?
Yes, Your Honor.
And are you satisfied with the services of your attorney?
Yes, Your Honor. Very
Mr. Goldsmith, are you privately retained or court appointed?
Court appointed, Your Honor.
The report of pretrial conference that was filed in this case on January 22nd, 2015 indicates in paragraph that is numbered number 1, a plea agreement in this case. Mr. Smith, is that the plea agreement as it stands today?
Your Honor, it is the plea agreement as set forth in number paragraph 1 of the pretrial conference. I believe my copy anyway has whited out on counts 2 and 3 of the trial information. It would be about the 5th, 3, 4, 5 sentence down. Dismiss counts 2 and 3. I don't know what yours states, but mine's whited out. So it would be plead guilty to count 1, dismiss counts 2 and 3, and then also apologize for not including probation through the Iowa Department of Corrections. It should read. That is the plea offer in this matter.
All right, Mr. Tingle, I've been informed that the plea agreement is that you would plead guilty to count 1 of the trial information, burglary in the 3rd degree, Class D felony, that you would be required to pay any restitution. You may be required to testify against any co-conspirators. That in exchange for your plea of guilty to count 1, the state would dismiss counts 2 and 3 of the trial information and recommend that you received a suspended sentence and placed on probation to the Department of Correctional Services in order to pay the minimum financial consequences. Mr. Goldsmith, does that accurately state the plea agreement in this case?
Yes, Your Honor.
And Mr. Tingle, is that your understanding of the plea agreement?
Yes, Your Honor.
What you need to understand is that while you may have this plea agreement with the state of Iowa, at the time that you are sentenced, the sentencing court, whether it's me or somebody else, is not bound by the terms of the plea agreement, and you could be sentenced to the maximum term that's allowed under law. Do you understand that?
Yes, Your Honor.
And knowing that, you still wish to plead guilty?
Yes, Your Honor.
If you continue in your desire to plead guilty, there are certain rights that you're giving up that I need to go through with you. You'll have to answer out loud after every right that I read to you. If you plead not guilty, you would be entitled to a speedy and public trial, but that is waived by pleading guilty and there is no trial. Do you understand that?
Yes, Your Honor.
At trial, you would be entitled to have your attorney present. If you could not afford one, the court would appoint one to represent you. In this case, Mr. Goldsmith's already been appointed to represent you. And if you wish to go to trial, he would continue to represent you. Do you understand that?
Yes, Your Honor.
At trial, you and your attorney would have the right to select a jury of 12 people. Do you understand that?
Yes, Your Honor.
You would have the right to cross-examine the state's witnesses. Do you understand that?
Yes, Your Honor.
You would also have the right to present evidence on your own behalf. Do you understand that?
Yes, Your Honor.
By pleading guilty, those rights are lost, and you and your lawyer will not have any of those opportunities. Do you understand that?
Yes, Your Honor.
Also, if you do not plead guilty, there is a privilege against self-incrimination, which means you cannot be forced to testify. If you decided not to testify at trial, the state could not comment upon your choice not to testify. But by pleading guilty, you're giving up this right. Do you understand that?
Yes, Your Honor.
At trial, the witnesses whose names are listed on the trial information would have to come into court and take the witness stand in front of you. And you and your attorney would have the right to cross-examine and confront those witnesses. But by pleading guilty today, no witnesses are going to come into court, so you will not have the right to confront nor cross-examine them. Do you understand that?
Yes, Your Honor.
At trial, you would be presumed innocent until such time, if ever, the state established your guilt beyond a reasonable doubt. But by pleading guilty today, you yourself are establishing your guilt beyond a reasonable doubt, and you are no longer presumed innocent. Do you understand that?
Yes, Your Honor.
At trial, you would be entitled to subpoena persons to testify on your behalf, but by pleading guilty, you are giving up that right. Do you understand that?
Yes, Your Honor.
And once again, all of those rights are being given up if you plead guilty. Do you understand that?
Yes, ma'am.
And do you now waive each of those rights as I have just explained them to you?
Yes, I do, Your Honor.
And you still wish to plead guilty?
Yes, I do, Your Honor.
The state has charged you with burglary in the 3rd degree, Class D felony in violation of Iowa Code sections 713.1 and 713.6A. The maximum penalty would be a prison sentence of up to 5 years. There would be a minimum fine of $750, a maximum fine of $7,500. There would be a 35% surcharge of any fine imposed, as well as a $125 law enforcement initiative surcharge. Because this is a felony offense, you would also be required to submit a DNA sample for testing, and also required to pay any restitution. Is there any restitution in this case, Mr. Smith?
Your Honor, trying to recall, no, there was not. All the property was returned.
Okay. In the event at sentencing, if the state requests restitution, the court will order it. However, you would be entitled to have a hearing to determine what the proper amount of restitution is if you contest the amount of restitution. Do you understand that?
Yes, I do, Your Honor.
Mr. Smith, has the court accurately stated the maximum and minimum penalties?
It has, Your Honor.
Mr. Goldsmith?
Yes, Your Honor.
The state would have to prove at trial that on or about November 21st, 2014, in Sac County, Iowa, you committed burglary in the 3rd degree upon the property of 1821 330th Street in Odebolt, Iowa. Would you please tell me in your own words what you think you did to commit this offense?
Cut a lock, went into a place and burglarized it.
All right. Were you in Sac County, Iowa on or about November 21st, 2014?
Yes, I was.
And at that time, did you enter an occupied structure?
Yes, ma'am, I did.
And what was the structure?
I'm not 100% sure. I think it was a machine shop.
All right. So it was some kind of outbuilding?
Yes, I believe so. A machine shed.
And would you agree that under Iowa law, that building constitutes an occupied structure?
Yes, ma'am.
And at the time you entered that building, did you have the intent to commit a theft in the building?
Yes, we did.
And you had no right, license, or privilege to cut the lock or enter the building, is that correct?
No, ma'am, we did not.
And when you did so, did you actually take some items?
Yes, we did.
And those items do not belong to you?
Yes, Your Honor, I did not.
Is the state satisfied with that factual basis?
Yes, Your Honor.
Mr. Goldsmith, are you satisfied with that factual basis?
Yes, Your Honor.
And once again, Mr. Tingle, is it still your desire to plead guilty?
Yes, Your Honor, it is.
Mr. Smith, do you know of any reason why the plea should not be accepted?
No, Your Honor.
Have I omitted anything which could affect the validity of the plea?
No, Your Honor.
Mr. Goldsmith, any reason why the plea should not be accepted?
No, Your Honor.
And have I omitted anything which would affect the validity of the plea?
No, Your Honor.
The court makes the following findings. The defendant is voluntarily entering the plea. He fully understands his rights and the consequences of his plea, and a factual basis exists for the plea. I previously ordered a pre-sentence investigation to be prepared. A copy of that has been placed in the court file. You need to understand that in order for you to get out of or challenge or contest the guilty plea that you just entered, the only way to do so is by filing what's called a motion in arrest of judgment. So if you think for some reason you should not have entered into a plea of guilty today, or that I have made some mistake in taking and accepting your guilty plea today, the only way for you to challenge that is by filing that document. That motion must be filed at least 5 days prior to your sentencing date and no later than 45 days from today's date. It's my understanding, Mr. Tingle, that you're requesting to waive your right to file a motion in arrest of judgment and that you wish to proceed to sentencing today. Is that correct?
Yes, ma'am, Your Honor.
So if you proceed to sentencing today, there's no window in time in which you can file that motion in arrest of judgment. So you're giving up that right to contest or challenge your guilty plea. Do you understand that?
Yes, Your Honor.
And knowing that, you still wish to proceed to sentencing?
Yes, Your Honor.
Is the state satisfied with his waiver of his motion in arrest of judgment?
It is, Your Honor.
And Mr. Goldsmith, are you satisfied?
Yes, Your Honor.
Regarding the pre-sentence investigation, at sentencing, you are entitled to have that report prepared and used at your sentencing. In this case, we ask that the report be prepared so it would be ready for today. Have you received that report and gone through it with your lawyer?
Yes, I have, Your Honor.
And Mr. Smith, you've received that also?
Yes, Your Honor.
Normally, you would have the right to be sentenced 15 days or later from today's date. But by pleading guilty today and asking me to sentence you today, you're also giving up your right to have 15 days at least to prepare for sentencing. Do you understand that?
Yes, I do, Your Honor.
And knowing that, you still wish to proceed to sentencing today?
Yes, I do, Your Honor.
Are you satisfied with that, Mr. Smith?
Yes, Your Honor.
Mr. Goldsmith?
Yes, Your Honor.
All right. We will proceed to his sentencing. Mr. Tingle, I've just accepted your plea of guilty to burglary in the 3rd degree in violation of Iowa Code Section 713.1 and 713.6a. The court accepted your plea and agreed to proceed with sentencing, and a pre-sentence investigation was provided to the court. I have received and reviewed that. I wanted to ask you, Mr. Goldsmith, Did you receive a copy of the PSI, and do you have any additions, corrections, deletions, or objections to its use today at sentencing?
We received it, and we have no corrections or objections.
And Mr. Smith, did you receive a copy of the PSI, and do you have any objections, corrections, deletions, or objections to its use today at sentencing?
Your Honor, the state did receive a copy of the PSI. The state offers no objection to the contents contained therein.
Mr. Tingle, I want to ask you, do you know of any legal reason why judgment and sentence should not now be pronounced?
No, I don't.
Mr. Goldsmith?
No, Your Honor.
Mr. Smith?
No, Your Honor.
There's too many Smiths. Did you have any evidence to present, Mr. Smith?
No, Your Honor.
I hear your recommendation. I know you stated the plea agreement earlier, but go ahead and make your recommendation.
Your Honor, the recommendation by the state is that the defendant receive a suspended sentence, and I guess, for the following reasons. One, the defendant was fairly cooperative with law enforcement at the time of the following his arrest and during the follow-up investigation. I believe that the PSI demonstrates some mitigating factors as it relates to defendant's upbringing that I think the court, should consider. And, the third, quite frankly, is I think that defendant can contribute to society and not be, I don't want to say a burden, but more of an expense to the taxpayers than he already would be by his incarceration, by giving defendant the opportunity to prove to this court that he wants to now contribute, be part of a functioning and contributing member of society that would be the state's desire, and that would ask that the defendant get that chance in this case. And if the state's wrong, at that time the state would seek to have his probationary status revoked and ask the court that he be sentenced to prison. So that's the state's recommendation and the reasons for it, Your Honor. Thank you.
To the extent that there was a plea agreement, Mr. Tingle, has the state complied with the terms of the plea agreement?
Yes, Your Honor.
Would you agree, Mr. Goldsmith?
Yes, Your Honor.
Did you have any evidence to present?
No.
I hear your recommendation.
We ask also that you accept the plea bargain, Your Honor. The reason mentioned by Mr. Smith. Everything not addressed in the plea bargain is restitution for court-appointed attorney fees. We would ask that you waive that. It is fine. 2 surcharges and court costs would be well over $1,000. At this point, he is incarcerated in Ida County, and I'm not sure what's going to happen there, but he's going to have at least significant amounts owed there. So we would ask that you, he's not employed at this point, obviously, because he's in jail. So we ask that you waive the court-appointed attorney fees because he can't pay it.
Thank you, Mr. Goldsmith. Mr. Tingle, you have the right to speak to me in mitigation of punishment. You're not required to speak to me, but if there's anything that you would like me to hear, now would be your opportunity.
Yes, Your Honor, stand up.
That's up to you.
Yes, Your Honor, I've committed the crimes and I'm sorry, and I appreciate the opportunity to prove myself, like Ben said, to prove myself that I could be a member of society and be productive. And I just want to apologize to all the people that I hurt and that took things from that didn't belong to me. Thank you.
Were there any victim impact statements, Mr. Smith?
No, Your Honor.
All right, Mr. Tingle, would you please stand? Based on the defendant's plea of guilty to the charge of burglary in the 3rd degree, it is a finding of the court that the defendant is now guilty of that charge in violation of the Iowa Code sections that I referenced earlier. Mr. Tingle, I want to inform you that I have considered all of these sentencing options that are available to me that would provide for your rehabilitation but still protect the community from further offenses by you. I've considered your age. You're a relatively young man. I've considered your educational background. I've considered your family circumstances that were outlined in the pre-sentence investigation report, including your employment background. I listened to the terms of the plea agreement that were presented to me, as well as the statements by both attorneys. I've also considered the nature of the offense itself. Mr. Tingle, for someone who's such a young age, you have quite the criminal history. However, the things that you've been convicted of are somewhat petty offenses, and you've never been placed on supervised probation to the Department of Corrections. I hope that by following the terms of the plea agreement that I don't see you back in front of me. So it will be the order of the court. You were given a 5-year prison sentence. That sentence is suspended. You're placed on probation to the Department of Correctional Services for a period of 3 years. You will be assessed a fine in the amount of $750 with a 35% surcharge. You'll be required to pay the court costs of this action. I will assess attorney fees for your court-appointed attorney. However, I do find, based upon your employment circumstances, that you're unable to repay the cost of your court-appointed attorney. You will, however, be required to pay the fine and surcharge, as well as a $125 law enforcement initiative surcharge. I will order restitution. The state has 30 days from today's date to file a statement of restitution. If you disagree with the amount, you can ask for a hearing like I told you earlier. It sounds like they are asking for any additional restitution. So if 30 days go by and they don't file anything, you won't have to pay any restitution. Because this is a felony offense, you will be required to submit a sample of your DNA for testing. You'll be required to sign up with the Department of Correctional Services and follow the terms that they set for your probation. With that being said, Mr. Tingle, I do not take probation lightly. I don't mind granting probation, but I expect you to follow the terms of your probation. Because if you violate the terms of your probation, Mr. Smith's going to ask for sanctions against you. And one of the sanctions that's available to the court, if you're found in violation of your probation, would be to impose the original sentence, which is 5 years in prison. And I see that you spent some time in jail, which is all county jail time. I can assure you, you will not enjoy any time that you spend in prison. I don't enjoy sending people to prison. However, I also will not lose any sleep if I have to send you to prison. But you're the person that's in control of that. So don't make the mistake that many people make and take probation lightly, because there will be consequences if you're found in violation of your probation. Do you think you're going to have any problems following the terms of your probation?
No, I know you're not.
Well, I hope that's the case. On motion of the county attorney, counts 2 and 3 of the trial information, as well as any companion simple misdemeanors, are dismissed. Other than appeal rights, Mr. Smith, anything else?
No, you're right.
Mr. Goldsmith?
No, you're right.
You do have the right to appeal my sentence by filing written notice of appeal with the clerk of this court within 30 days of today's date. If you cannot afford the cost of an appeal, you can apply for the appointment of counsel and a furnishing of the transcript at state expense. Filing that written notice of appeal in the time and in the manner specified in the rules is jurisdictional, which means if you fail to do so, you'd be forever barred from appealing my sentence. Mr. Goldsmith is an experienced defense attorney. He can assist you in that process if you wish to appeal. Bond on appeal will be set in the amount of $5,000. Anything further, Mr. Smith?
No, you're right.
Mr. Goldsmith?
No, Your Honor.
All right, good luck, Mr. Tingle. Court's in recess.
Thank you.